Good morning. I'm Andrew Warren, a partner in the real estate group at Wakeman's, based in the Glasgow office, and I also sit on the firm's COVID steering group. Thanks for joining us on this session where we're going to take a look at some of the issues which we see on the horizon for leases as we move into the post-COVID phase. This follows on from a session which we held yesterday, which some of you may have joined, focusing on property management and insolvency issues. The focus of the session now shifts to business and what business might encounter as they work through the changes which may be experienced across the various business sectors and how that may impact on lease negotiations and provisions in leases. The format of the session will follow a structure which you will probably now be familiar with. We have put together a panel who I'll introduce shortly. The session has been split into a discussion around leasing from both the perspective of the landlord and tenant. We also have a section looking at the position on lease renewals under the Landlord and Tenant Act, and finally a brief compare and contrast with the position for leases in Scotland. Following the panel contributions, we'll round up the session with a question and answer section where we can pick up on some questions which have been submitted in advance of the webinar this morning, and if time permits, other questions which have come in during the course of the seminar. Before I introduce the panel, a couple of housekeeping points for you. Firstly, in terms of sound, you can select the audio preference on the panel as shown on the screen. Next, if you want to raise an issue, then please select the hand button on the panel and the organiser will contact you to assist. And for any questions that you have, if the questions can be put into the question box which appears on the screen. So, turning to the panel, firstly we have Helena Liebster, who leads the commercial real estate team in London and has extensive experience operating across all asset classes for landlords, including retail, office, industrial and mixed-use schemes. Helena's clients span PLCs, property companies, developers, banks and private investors. Helena sits on our firm's digital advisory board and on the events committee of Women in Property. Helena will consider leasing issues from the landlord's perspective. Matthew Williamson is a partner in our head office in Liverpool and advises on complex landlord and tenant matters and also high-end disposals with particular expertise in dealing with overage and anti-embarrassment provisions. Matthew is the sector lead for our firm's retail and supply chain offering and is product manager for our firm's OneView property management product. Matthew also sits on the property advisory board of the UK Warehousing Association. Matt will consider leasing issues from the tenant's perspective. And last but not least, Peter Hall is a senior associate in our Manchester office and specialises in property litigation, including lease renewals and terminations under the 1954 Act, service charge disputes, dilapidations and removal of trespassers. Peter also has an interest in the PACT process for lease renewals and will also be covering that in his contribution. So without further ado, I'll now hand you over to Helena and Matt for their thoughts on some of the changes we may see to lease provisions post-COVID. Helena, Matt.
Thank you, Andrew, and good afternoon, everybody. Thank you very much for joining us on this rather rainy afternoon. During this part of the webinar, we will be looking at the effect on current and future lease negotiations. We will look at turnover leases, the amendment to lease provisions, new lease clauses, lease security, the Lease Code 2020, and the potential landlord and tenant code of practice. Looking first at turnover leases. The ongoing challenges in the retail sector are well known and COVID-19 has only exacerbated them. Will turnover leases become more prevalent? We think that they may well do so, particularly in the retail sector. A turnover lease is a greater risk and in good times, reward sharing between landlords and tenants. It's an investment by the landlord in the tenant's business and leads to greater landlord and tenant collaboration. But the landlord has fixed costs and perhaps fixed debt repayment liabilities, and so would need their lender on board. Landlords and tenants would need to agree whether it's a pure turnover rent or a combination of base rent and turnover top-up, what the level of base rent should be, and what the turnover rent percentage should be. Now, typically, a base rent is about 75 to 80% of the total. Now, the mix can be tailored to suit both parties during negotiation. Now, a landlord will want some element of the rent to be fixed, and the landlord will want a greater percentage, turnover percentage, the greater the turnover element, i.e. the greater the risk element. The parties would also need to agree the scope and the impact on other covenants. For example, assignment and underletting provisions. What works for one tenant might not work for another, and the landlord might want to switch back to a full open market rent. They would also, the landlord and tenant would need to agree deductions. Now, that may depend on the user of the premises. For example, if the premises is being used for a restaurant use, service charge tips, should be a deduction. Other agreed deductions could be VAT, interest charges, cash refunds. How should online sales be dealt with? And as a landlord, you're going to want there to be trading covenants. You need the tenant to be trading from the property in order to maximise the turnover and in turn maximise the turnover rent. And then you've got the verification of turnover. That's a big compliance exercise and can be very, very tricky. And we also think that turnover rents may become more prevalent in other sectors as well. One that springs to mind is the co-working sector, where the landlord has a lease of premises and the turnover rent could be a percentage of the license fees they receive from their clients. It will be interesting to see whether turnover leases do become more prevalent. Matt, what are your thoughts from a tenant's point of view?
Yeah, well, thanks, Helena, and good afternoon, everybody. From the tenant's point of view, just picking up on a few of the headline issues which you raised there, and what the sorts, the tone, the meaning of the conversations that we're going to have post-COVID. The first one is the profile of the rent, the level of a base rent in a turnover rent situation, which, as you say, probably, I'm not saying it's passé, but we've seen it more in retail than in other sectors, perhaps for a longer period now. But we've all as well heard about the death of the high street. Not quite convinced that that's there yet, but times are changing. And as you rightly said, that the COVID situation is going to be a catalyst for that change. I would query, because we've been, dare I say, stuck with the Landlord and Tenant Act 1954 for some time and its various amendments for a while now, is the methodology that sits behind that statutory framework still fit for purpose based on the changes that we are seeing and no doubt will see in the future? In that context, I'm talking about looking certainly retail in terms of Zone A. Now, historically, again, whilst this is very much the reserve of the surveyors who would look at this in particular, is that now a suitable methodology, given that you may have, for example, a store which was ostensibly very much customer facing and effectively acting as a showroom? There may be more of a shift now in some instances, and for some retailers and for some people who trade on the high street, to having more of these dark store concepts where they're a combination of both a customer facing function and a shop in the more conventional sense, but they also act as a stock repository. Dare I say, if you're operating a spoke and hub method from your supply chain, then you may be doubling up on these stores as distribution hubs as well. So I would query whether or not the rent valuation that we've historically used still applies to them. On the turnover percentage point which you raised, I would say that whilst a lot of the carve-outs, the assumptions and the disregards, if you like, which go into a turnover rent calculation are valid, post-COVID we need to be looking at things like carving out some of the government-backed schemes that have assisted retailers conceptually quite difficult, I think, for a landlord to argue that those things which have kept businesses afloat should count towards turnover. And I would qualify all this by saying that it's one very much to have your accountants look at in advance before agreeing any turnover rent provisions. Also, a lot of tenants at the moment, they're seeing concessions in the rent payment profile. The lease hasn't changed, it's just that they've been able to do a deal with the landlord to either defer or take a break from the payment of rent for a certain period of time. Check with the accounts function of the tenant whether or not there's any VAT implications on that, which may impact upon your turnover rent calculations. A very headline point as well, whether this was triggered by COVID or not, if we're looking at turnover rent and sort of landlords and tenants working together and sharing that risk, which is ostensibly what the thinking is behind some of the turnover provisions, are we going to start seeing some of the pushback from some tenants saying, look, you really need to help us out here, guys. You've got the MI, you've got the data that sits behind your high street, your development, your shopping centre, your outlet store. You know what your footfall is across the whole scheme better than us. This is some of the reason why we pay our service charge. Can you help us out in coming out with putting a bit more rigor around what those turnover figures should be based on things like footfall? I mean, the tech is there to help people. Beacons have been around for years now, and that information, I think, is going to be a prevalence in looking at that and seeing how it colours people's decisions on what the makeup of a turnover rent is actually going to be.
I think that's very interesting, Matt. And as you say, I think the high street is going to have to transform. Landlords and tenants are going to have to think of ways to increase footfall, which may be kind of new leisure concepts as well, to get people onto the high street, into the shopping centre, to increase the footfall, increase the turnover. So I think it is very much working in partnership together, and then negotiating turnover rents, even profitability rents. And I think it's very important that you have other professionals on board with that as well, the accountants, also the surveyors who are negotiating the heads of terms, that they're familiar with how turnover rents work. Turning to your more typical lease, how may kind of other lease provisions be amended in that? For example, rent suspension clauses jump out. Should these apply in a pandemic? Should they just cover pandemics or force majeure scenarios more generally? Now, from a landlord's viewpoint, if the premises are capable of being used, there should be no rent suspension. Also, a landlord needs the rent certain, maybe to service its debts, and is going to be reluctant for, rent suspension clauses to be triggered. Now, we think that it's probable that going forward, an industry standard provision will be developed, as we've seen with, the uninsured risk provisions over the last 10 years. Matt, what do you think?
Yeah, I think that's right. I think from the tenant's perspective, of course, no one really saw COVID coming. We don't know what the future holds. No one has a crystal ball. I think, and we'll come on to discuss insured risks later on and what that comprises. I think from the tenant's perspective, certainly the one that I've been dealing with of late, whilst there was an initial glut of people running around trying to put letters together to document whatever concessions there were, the other side of all this, I think that tenants need to ideally link it to what the government advice is at the moment, which of course changes as the situation evolves. And to pick up on one point that you made, it's this concept of, well, look, if you can still use it, then the rent shouldn't be suspended. That's fine in principle, but I've had a couple of issues where landlords have attempted to link that to what have been extremely broad user covenants. And of course, the Town and Country Planning, the use classes orders which sit there have no regard to pandemics or what's going on in the world or government guidance in that regard. So there's a bit of a disconnect there, which is no one's fault. It just needs to be addressed and certainly negotiated. Sorry, when leases are being negotiated in the future, that's one thing to look at, because of course, if your user clause is worded positively, it can be construed as a keep open provision, which during a pandemic's causing a problem. Now, woe betide any landlord then goes to court to get an injunction to compel a tenant to open, not that you could, and there's case law to say that that wouldn't be applicable anyway, but theoretically at least, PR issues aside about landlords doing this, theoretically, if you breach your keep open covenant, then damages could be payable. So on the other side of this, just have regard to keep open provisions in the context of what your uninsured risks are and your rent suspension clauses as well, and what those triggers are.
No, yes, that's right. And you touched on, insured risks there, and generally the standard lease at the moment, the pandemic situation is not an insured risk, and therefore doesn't trigger a rent suspension. Hence why we're seeing lots of tenants approaching landlords and asking for rent concessions, which the landlords are not obligated to do under the terms of the lease. Length of term is another thing that may be amended going forward. Are tenants going to require greater flexibility, perhaps shorter terms, but coupled with, in addition to statutory options to renew, contractual options to renew as well? Will they want more break dates, fewer or no break conditions? I mean, that's not going to be popular, from a landlord's point of view. Landlord, you want no arrears, material compliance, ideally vacant possession. I mean, the lease code has already watered that down to, giving up, free of occupation. What do you think about that, Matt? Do you think tenants are going to be wanting shorter terms? I mean, that means less SDLT as well, of course.
Yes, yeah, which is a plus. I think, dare I say, depending on which sector you operate in, shorter terms have become more and more prevalent. I mean, the old style of the 25-year institutional lease for certain sectors just isn't applicable anymore. What I would say at sort of a macro level, certainly retail, leisure operators, the sort of the terms that are being negotiated now, again, on the other side of all this, because we have had to, out of necessity, certain sectors of society shop online, do things that they wouldn't have done previously, then there will be some people who that way of dealing it will be sticky. That will be their new normal. And I'm not a massive fan of that expression, the new normal, but because I think it's been overused. But I do think that will, yeah, quite. But I do think that will be it. And certainly some of the data that is coming out of China, one of the few things I can say about the new normal, certainly from the data that we have seen, is that there have been some quite fundamental changes to some sections of society as to how they do things. I think all of that feeds into very fundamental commercial terms in leases. So we're talking about rent and term. And so, yeah, I think those are the sorts of changes that we'll see.
We touched on earlier keep open clauses. Now, if we do have a move more towards turnover leases, these are going to be, increasingly, important. But also, where you've got, shopping centres, for example, you want the units open to make sure, people are coming into the shopping centre and spending money and visiting other stores and restaurants as well. Now, we already have certain carve-outs from keep open clauses, for example, for stock taking, an assignment, and probably will need to add a carve out where you legally can't open as well, and that ties into what we were talking about, the user clause as well. So at the moment a lot of shops can't open, but from Monday they can, and I'm very much looking forward to that. I think actually I might have to have a day's holiday on Monday to go and visit some boutiques, help the high street out. So what other
Could I just interject, Matt, Helen, at this point, just to say in terms of keeping tabs on the timing, we're about 10 minutes of this part of the session to go.
Okay, thank you, Andrew. So what about other provisions in leases? Well, rent reviews. Are upwards only rent reviews, going to become less common? Will there be a disregard of any future pandemic force majeure situations? What about the assumption that premises are capable, of beneficial, occupation and use? What's your thoughts, on that, Matt? Do you think tenants will be seeking amends to rent review provisions?
I think I think they will. I think people will be having more regard to the assumptions and disregards that appear in the rent review provisions to cater for exactly that. It goes back to the point I made earlier about the changing way that we shop, which started prior to COVID anyway, but dare I say has been accelerated by it. So looking at what the, that overriding, what is the market value of this lease concerned, is in terms of Zone A still relevant. And it also the data that some landlords do have, although there's some interesting stats out there at the moment about how widely it's been used, but I think that has to come more to the fore to educate and colour the discussions between landlords and tenants to see what that is. So yeah, I think those sorts of considerations will start to come into what is considered a normal lease for those types of sectors.
Also restrictions on, use and alienation, are these going to become more relaxed due to increased business uncertainty? Now, from a landlord's point of view, a landlord wants control of how their premises are used. I mean, particularly, if you own the high street or a shopping centre, tenant mix is important. And also, landlords, want to have control of who is occupying their premises. Next slide. So other provisions that I think may be, amended, I'm just conscious of time here, are repair, service charge, cleaning obligations, health and safety. What about the payment of rent? We touched on earlier that lots of tenants are asking their landlords for rent concessions. Quite a popular one is a switch to monthly rather than quarterly payments to help with cash flow. Might that become more the norm and be drafted into leases? I think that perhaps a trade-off for greater flexibility in the lease might be more security. Will rent deposits become more common? So at the moment, a landlord, is unable to forfeit a lease because of forfeiture, moratorium for non-payment of rent, but landlord can withdraw from a rent deposit. So will landlords, require more rent deposits, greater rent deposits? Albeit you can't forfeit if a tenant doesn't top up, but it might help with cash flow. Other new clauses that we might see introduced into leases, a couple more slides, Andrew, are force majeure clauses and also good faith clauses. Then we've got the Lease Code 2020. Now this comes into effect from the 1st of September 20 this year, so in a couple of months' time, and that seeks to improve the quality and fairness of negotiations on lease terms and to promote the issue of comprehensive heads of terms that should make the drafting process more efficient. Now, will these be amended in light of COVID-19? Well, we don't know, but one thing that we do know is that the government has announced that it has brought together a working group with the aim of producing a code of practice to support the high street. The code is going to encourage landlords and tenants to work together. Now, it's intended to be a temporary measure, but it could be mandatory if necessary. The aim is to publish the code before the June quarter day on the 24th of June, so just later this month, and the current end of the forfeiture moratorium period, which is the 30th of June. Now, we've heard no whisperings of any extension of that, and of course, what with shops, being opened on the 15th of June, that the government may well not extend the forfeiture moratorium period expiry date. I think what is clear is that going forward, and is already envisaged by the Lease Code 2020, is that greater collaboration is going to be key between landlords and tenants. That brings an end to that part of the session. So to hand over to Peter now, who's going to talk about the effect on the 1954 Act lease renewals of COVID-19. Thank you.
Right, thanks Helena. My name is Peter Hall. I'm a principal associate in the property litigation team. So I'm just going to be saying a few words about the effect of COVID-19 on statutory lease renewals under the 1954 Act, looking at 5 issues: rent, interim rent, other lease terms, any delays we're having to court process due to the current circumstances, and finally, is there an alternative to going to court, and if so, what is that and how does it work? So rent, the first important point about determining rent under a statutory lease renewal is the valuation date is the date of the hearing. So it is not the date of your section 25 or section 26 notice. It's the date of the hearing, the date when the court eventually hears evidence in the case and determines the terms of the lease. So if any tenants at the moment may be thinking this might be a good time perhaps to serve a section 26 request, kick off a statutory lease renewal, perhaps take advantage of some of the disruption in the market, obtain a lower rent, well, that may or may not be a good strategy. It will really depend on what market rents are in a year or maybe 2 years' time when that renewal finally reaches court. So we've heard a little bit about, I think we touched briefly on some of the assumptions and disregards which get written into rent review clauses in leases. So it's important to remember under a statutory renewal, there are also assumptions and disregards, but they are imposed by statute, namely Section 34 of the Landlord and Tenant Act. They're a bit more rudimentary and probably a bit more tenant friendly than what you would typically have written into a rent review clause in a lease. And crucially, of course, statutory lease renewals are upwards or downward in terms of the rent. So all of these really combine into a set of reasons why shorter leases of 5 years or less are attractive to tenants, because at the end of the term, if you want to renew, you will have the rent determined by the court under Section 34, which is normally more favourable to you than having it determined under a rent review clause that might be written into a longer lease. So, you know, lots of reasons why tenants want shorter leases. Just very briefly, the assumptions, there is an assumption of a willing landlord. There is no assumption that there is a willing tenant who wants to take the property. And there is also no assumption that the property is capable of beneficial use. So those, compared with what you might have in a lease, might well play into a tenant's hand. However, conversely, and I'm thinking in terms of the current circumstances where we've had a lot of businesses have been closed, there is a disregard of the tenant's occupation and any goodwill of the business. So for instance, a pub that's been closed for several months, if they've lost their regular trade, well, that isn't strictly something that would fall to be considered under a statutory renewal. Interim rent. Now, interim rent is intended to cover the gap between the process, the lease renewal process being started by service of a Section 25 or Section 26 notice, and the renewal lease eventually being agreed and completed. And depending how quickly this happens, this can be a gap of many months, sometimes running even into years. So this starts on what is defined in the legislation as the appropriate date, which is the earliest date that could have been validly put in the Section 25 or Section 26 notice when it was served. Normally that's the last day of the lease, but if there's been a delay in serving the Section 25 or Section 26 notice, it may be a later date. So this may cover possibly a fairly long period. There is a general rule, which is that the interim rent is the same as the new lease rent. So when a lease eventually completes, there is typically a reckoning. If the rent is going down, then the landlord will have to refund money to the tenant. If it's going up, the money goes the other way. However, as with all general rules, there are some exceptions, and these exceptions don't apply very often, or at least they haven't in the past, but I can certainly see in the current circumstances, these exceptions may become more common than they have been in the past. So I've just got a couple of exceptions up on the slide. This isn't an exhaustive list. One exception is where the new rent differs substantially from the relevant rent. So the relevant rent is what the rent would have been if the valuation date had been the appropriate date, namely the earliest date that could have been put in the Section 25 or Section 26 notice. So this will only apply if there's been a big shift in market rents in the period between the notice being served and the rent ultimately being agreed or determined. So normally this doesn't really happen very much, if at all, but I can see in the current circumstances there may be cases where this might happen. It's something to be aware of. Do not automatically assume that the interim rent will always be the same as the new rent, where we've seen a lot of disruption to the property market. Another exception, the second one up on the slide, is where the terms of the new tenancy have been changed from those of the old tenancy, and where that has a substantial effect on the rent. So if, for instance, you have a case where a tenant has successfully persuaded the landlord or the court that there should be new terms going into the tenancy, perhaps to suspend the rent if we have a repeat of what we've just been experiencing over the last few months, that's something that might go in the tenant's favour. Would that have a substantial effect on the rent? Well, that's something you would have to have a think about, and if it would, then again, the general rule that the interim rent is the same as the new lease rent may be displaced, and the interim rent may be different. So we've touched on earlier about new clauses that tenants might want to have in leases going forwards. I think there probably is going to be an acceptance that things have changed, and that tenants are already seeking clauses to try and protect them from any repeat of what we've just experienced over the last few months. These clauses may start appearing in leases. So can tenants effectively have their leases changed by going to court, running an argument, this is modernisation, it reflects the modern market? Well, it's not necessarily that straightforward, because the court's jurisdiction to determine the terms of the new lease are prescribed by statute. So the two sections of the 1954 Act are up there on the slide. One section deals with the duration, length of term, which is section 33, and that simply must be reasonable in all the circumstances. So there is no precedent there for a long lease being replaced by another long lease. If a long lease comes to an end, the length of the new lease is simply what would be reasonable in all the circumstances. And where, as we've seen in the last few years, the market has moved towards shorter leases, I think that there is an acceptance by the court that shorter leases probably are now going to be reasonable in all of the circumstances in a case where the parties can't agree the length of term. Now, the other terms, apart from rent and duration of term, are prescribed by section 35, which does require the court to have regard to the terms of the old lease. So where a tenant wants to run arguments based on modernisation, these aren't necessarily that straightforward. The court must look at what was in the old lease, and the way it does that has been set out by the courts in the well-known case of O'May, which is still good law. And in O'May, the court said that whichever party wants to change the terms of the lease, whether that is the landlord or the tenant, there is a burden on that party to show that the change is fair and reasonable in all of the circumstances, and simply modernisation may well not be good enough. I mean, the O'May test actually concerned a case where the landlord wanted to put service charge provisions in a new lease, and this was in the early 1980s when it had been well established for some time that that was what modern leases included. But in the O'May case, the court said, well, no, this is a change that exposes the tenant to variations in service charge from year to year. That only really benefits the landlord and not the tenant. So although it's modernisation, we're not going to order it. So I think tenants will find this case getting thrown back at them fairly regularly in renewals over the next few years, where they're trying to have the terms changed in their favour. So court process. Currently, 1954 Act claims are heard by the local county courts. The courts are busy with work they haven't been able to deal with as usual due to the COVID-19 crisis. So whatever delays you may have experienced in the past with 1954 Act claims, I think those are only going to get worse. What will the courts do about this? Well, at the moment, we haven't heard any proposals. There are some options. For instance, there was a pilot scheme in 2018, which has now come to an end, where 1954 Act claims in central London were transferred out to the first tier property tribunal, who can deal with them quicker than the courts could. This might be something that gets resurrected, we'll have to see, but certainly as things stand, the courts are busy, delays can be expected, so I think these claims may, if they get issued, they may well sit around for a while before the courts are actually able to deal with them. So is there an alternative to going to court? Well, there is. It's called PACT, Professional Arbitration on Court Terms. So it's a form of alternative dispute resolution, i.e. the parties to a dispute decide that an independent third party will decide the dispute rather than the court doing so. The courts generally the civil courts are pretty keen on ADR, alternative dispute resolution, and they can penalise you on costs if you don't use it. However, there hasn't been a case concerning the 1954 Act that I'm aware of where that has yet happened, and indeed I'm aware of a case where the courts actually refused to impose any cost sanctions on parties who didn't use PACT. Though I would query going forwards if the courts are going to be busier than usual and they don't really want to be hearing 1954 Act cases, might they move in the direction of penalising people who don't use ADR? Quite possibly. So quickly, how does PACT work? Well, it's designed to be fairly flexible. It's a scheme drafted by the Law Society and the RICS. It can be used either before or after 1954 Act proceedings have been issued, so you don't have to have already issued proceedings in order to use PACT. You can have either a surveyor or a lawyer, and if you have a surveyor, they can be either an expert or an arbitrator. An expert is really only suitable if you've agreed everything that goes in the lease other than the rent. Anything more than that, I think you really need an arbitrator. The people who promote the scheme say it's quick. Well, in my experience, it's not perhaps as quick as it could be, but it's still quicker, I think, than going to court. I think you would be possibly from start to finish, if you had things in dispute that included other lease terms, not just the rent. I think you might be looking at 6 to 9 months, which does actually compare fairly favourably with the court. So yeah, I think we may well see PACT becoming more popular in future, as long as both parties are agreed it's something they want to use. So I'll now hand you over to Andrew.
Thanks very much for that interesting and enlightening run through renewals and the PACT process, Peter. It'd be interesting to see if we now see a greater uptake on that going forward. And also, Helena, Matt, that was a very interesting run through the position of Leases. A lot of food for thought there and interesting content, and I'm sure we'll see that feeding through into the question and answer session at the end. In particular, it's good to see that there's an ongoing narrative to retain the collegiate approach which landlords and tenants take to negotiation of leases these days, which we've seen develop over the course of the past 10 to 15 years or so. Hopefully the strain that's been put on that, partly by CVAs, I think, and also by this development under COVID, will not see the philosophy of a more collegiate approach move into reverse gear. I'll now have a look at the position on leases in Scotland, briefly run through that. Firstly, the likely position on commercial discussions around leases and the introduction of new clauses in Scotland is unlikely to be different from the position of England. So I would simply echo the comments of Helena and Matt in the course of their discussion. The explanation for that is that in broad terms, the structure and format of an FRI lease in Scotland is very similar to the format of a lease in England. And the reason for that is that in the early 70s, the form of lease which was employed in England was more or less adopted wholesale into Scotland for commercial properties. So with the exception of some differences in terms of legal terminology, the form of lease used in each jurisdiction is broadly similar and sets out to achieve the same goal. What is, however, important to recognise is that the underlying legal systems in which they operate are completely different. In England, the application of the law of leasing is substantially governed by Landlord and Tenant Act. In Scotland, the Landlord and Tenant Act doesn't apply, and there's no equivalent legislation in Scotland. It's governed by the common law in Scotland. As such, there's a greater significance in ensuring that what you want the lease to do is clearly specified in the lease. So, for example, if a party is to act reasonably in the context of some obligation or entitlement under the lease, you'll need to state that. And what is reasonable will ultimately be determined by the court according to circumstances. A few key differences just to mention for you to be aware of. There is no security of tenure in Scotland. So all of that good stuff that Peter's spoken about there in connection with lease renewals doesn't apply in Scotland, other than in the case of one limited exception. The lease will therefore come to an end on its termination date, provided, however, that either the landlord or the tenant or both have served a notice to quit. The notice to quit, in the case of most FRI leases, will be a notice served not less than 40 clear days before the termination date, and it needs to be served in accordance with the notice provisions in the lease. Critically, if the notice is not validly and timely served, the doctrine of tacit relocation will apply, whereby the lease will continue for a year on the same terms and conditions, which could, of course, have significant implications for either party. Picking up on the comments of Helena and Matt on the potential changes to these terms, a handful of practical points to flag, looking particularly at the instances of a situation where that might come through as part of a restructure or a re-gear proposal to extend a lease in Scotland. In Scotland, there is no surrender and re-grant process. The approach which is taken is simply to vary the lease by way of a minute of variation or extension. So where a lease is being extended, there may be a need to consider the implications of LBTT liability. LBTT, Land and Buildings Transaction Tax, replaced SDLT in Scotland in 2015. It's broadly the same tax regime, but it's refined to address the leasing law system in Scotland and has some differences, including the 3-yearly return process. A specific point to note is that the lease is being extended was originally an SDLT lease, and then it will become an LBTT lease. And in certain instances, it's possible that the tax payable will be greater in Scotland than would be the case in England, because overlap relief will not be payable, available, given that the two tax systems are in different regimes. It's also worth noting that where the lease extension takes the total duration of the lease beyond 20 years, that may also create an additional cost and administrative layer, as it will then be necessary for the lease to be registered in the land register. And just a final point on that, for a lease to be capable of having a fixed security over it, it would need to have a duration of over 20 years. So both the lease and the fixed security could be registered. I've certainly seen that crop up on a couple of occasions in certain types of transactions, given that in England it's technically possible to put a security in place over a lease which has a duration of more than 7 years, which I think is the period for registration in England. So in conclusion of this section, I think it's just a case of having an awareness of the fact that whilst on the surface leases in Scotland might look similar to leases in England, they're not in fact the same. And in particular, care should be taken not to make assumptions that what might apply and work in England will also apply and work in Scotland. So I think that leads us now on to the question and answer session. And we've had a number of questions which have come through before the event today. And if I may, I'll just turn to a few of those questions. Firstly, question probably to be directed at you, Peter, in the first instance, given that it may have implications in terms of the position on enforcement. Do you think that landlords will be keener to obtain rent deposits in the future?
Well, I think they may be if they can get them, Andrew, because you know what we've seen over the last few months, as anyone who attended yesterday's seminar will have heard, is that the government introduced restrictions which made it harder for landlords to take steps to recover rent, for instance, by exercising CRA, or is more difficult, and forfeiture's been banned altogether. So if a landlord had a rent deposit, clearly they were in a better position, because nothing in the legislation stopped the rent being due or reduced the rent, just simply the enforcement options were more limited. So if a landlord had a rent deposit, clearly they were in a better position. They could simply draw on the deposit. So yes, I think in future landlords who have suffered over the last few months will be keen, if they can, to get rent deposits. Though obviously the quid pro quo of that is, you know, we may be moving into more of a tenant's market, you know, particularly for certain types of properties. If tenants aren't willing to pay them, then you know, landlords won't be able to get them, and the courts won't order them in a statutory renewal either, unless there is a good reason and it's reasonable in all of the circumstances, which, you know, generally won't be the case unless it is accepted in the market that that type of lease would require a deposit, and you know, almost certainly where the previous lease was subject to one as well.
So Matt, do you have any particular thoughts on that from a tenant's perspective?
I mean, a rent deposit, although there used to be sort of conventions around how much you put in, I think the only things I'd say would probably be at a sort of a macro level rather than at the individual drafting, because I do think that, as Pete says, it for certain sectors it is certainly going to turn into a bit more of a tenants market. I think that the profile of what's acceptable, I think that the days of a landlord, and again this is landlord by landlord basis, but for my money, with my tenant hat on, I'd be saying the days of having a standard approach across a portfolio to say you know, our requirement is X by way of security, whether that's rent deposit, cross-company guarantee, PGs, even things like that. I think that people are going to have to look at it on a much more case-by-case basis, but then that feeds into the bigger picture about the market generally. So yeah, I think that what Pete said, he's absolutely right. I mean, the main thing from the tenant's perspective, of course, is all of this is just all the current legislation, and query what happens on the 30th of June. With this quarter date rapidly approaching, is only to stop enforcement. It doesn't, you know, a lease is a contract. It doesn't mean that the rent isn't payable unless you have specifically agreed with your landlord to take those steps and include an actual rent holiday distinct from a deferment. But that will play out, because Helen can comment on this possibly better than I can, but certain landlords will have their red lines, they will have their banking covenants, they will have their absolutes, which, you know, are dictated to them. How that plays out over the next few months remains to be seen. So we will see. Yeah,
any thoughts on that, Helen? I mean, obviously we have this moratorium period at the moment. We also have that problem, but clearly it's just a moratorium period. The problem hasn't gone away. If rent's not being paid, issues still need to be picked up.
Well, yes, I mean, at the moment on the 30th of June, all rents become, you know, payable again, and you know, I think landlords will be, you know, seeking for that rent to be paid, you know, or rent deposits to be topped up where they've had one and they've been able to, you know, withdraw, you know, from that. A number of tenants, you know, have approached landlords for various, you know, rent concessions, you know, be it rent holidays, deferment of rent, monthly rent, and you know, we always recommend, you know, that they are documented. You know, I think, you know, going forward, it's a matter of negotiation between the parties. Yes, it looks like, it's becoming, more a tenant market, but, as a landlord, if you're going to give concessions in other areas, one thing you might want, it is a rent deposit, and it might depend as well on the type of premises. We may see kind of going forward that, if landlords, can be, smart and, attract, tenants into their premises, that there might be high demand for, certain shopping centres, particularly ones which are offering, other experiences, to get the footfall in. So I think it will be very interesting to see. I think it's just going to accelerate, in particular in the retail sector, the transformation of what the high street looks like.
Yeah. Okay, I've got another question here, which is possibly directed initially at you, Matt, but maybe you could pick up on it as well from a landlord's perspective, Helena. From a tenant's perspective, what do you see as the three main terms within a lease that a tenant might need to look at post-COVID?
Thank you, and whoever sent that in, thanks for that. I think for me, the killer one, certainly with COVID so fresh in everyone's mind, and this is the reason why we're sat here today, certainly rent suspension, the triggers for that, trying to cater for the unknown. The ability to suspend is often linked to insured risk, or dare I say uninsured risk, but whether or not, and there is some case law, not out of COVID, but generally about questions of what was in the contemplation of the parties, there's no problem in spelling out in very clear terms, and of course that should always be encouraged, exactly what the parties meant to say by including certain provisions. So if you want a pandemic suspension clause, you write that in, and yes, it might get bounced around a few times, but there's no reason why you can't do that. And I would always say, with my tenant hat on, if that's something that you want, you should push for that. Yes, landlords may come in and say they're not accepting it, but at least have the conversation. The second point's user. As I said earlier on in the presentation, I think that the use classes order and how broad they can be don't match, nor were ever intended to match, in fairness, to the list of premises which are deemed to be essential services and then will remain open. This is in the context of a user provision being interpreted if it's positively worded, i.e. you must use it for use X, Y, and Z. You don't want somebody to go to court and say, well, look, you have to stay open. I think that there are issues around there as well if you have sublet, and because the use class orders are so broad, if you have sublet to somebody which ostensibly is within the user for the building, but actually is deemed to be an essential user in the case of a pandemic, you may have a situation where they can remain open under the user clause and they can continue to trade, and indeed are in a better position to pay rent, but their immediate landlord isn't and has to shut. And how do you cater for that? That's another one to look at. And the last point I'd say is where you do have a turnover provision, and as I said, some sectors that may be becoming more prevalent than others. I'd love to see a profitability test in there rather than just pure turnover, but I appreciate that the rent, if you have a base rent, is a known fixed cost, and you'd include it probably as part of your turnover calculations. But especially in how we buy things, how that's changed, where does the transaction actually happen? When is that order fulfilled? It's those sorts of things that people are going to have to be extra clear on in order to make sure there's not unintended consequences as a result of some drafting that it just doesn't do the job that it was supposed to do. So, as I say, for my money, the top three: rent suspension, user, and the methodology of any turnover rent provisions.
Yeah. Any particular thoughts on that from a landlord's perspective, Helena?
Well, I think, as Matt said, it's important actually, for both, parties that, there are no grey areas in the lease, and it's quite clear, what was meant, by the parties, not least to avoid ending up, in court and the costs associated with that. But I think, from the landlords, point of view, that they want, certainty. Landlords, have costs. They want to have an income from the property. They may have, debt to service. So they don't want, rent suspension, just to be, triggered, by anything. There's got to be an agreed, appropriate, sharing of risk level. And that will in part depend on the bargaining position of both parties. But also landlords have lenders, and, they need to be, it needs to almost be a tri-party, conversation. And also from a landlord's point of view, not going to want to agree terms which aren't, market standard, because that affects the landlord's, ability to finance, for the property, needs to be, security. So landlords are more likely to accept things which become market, industry norms.
Yeah, just looking at time here, I think we've probably got time for one further question before we wrap up the session. Other questions come in here. Is that should I pay insurance and service charge money? Any particular thoughts on that from the panel?
Well, as a landlord, my landlord hat on, I would say absolutely. They are due under the lease, and if they're not paid, they will be arrears. A landlord's got to insure the premises, and a landlord has to maintain, common parts and provide very important services, such as cleaning and deep cleaning. So I would say yes, absolutely, they should be paid. Matt may have a different view.
Well, for some of it, it's difficult to argue, especially where you've got sort of multi-user sites and certain people. I mean, it's that age-old argument that somebody on the ground floor, should they ever have to pay a service charge contribution towards a lift? That's analogous here. I think it may be the best that a tenant could argue for, subject to negotiation, would be perhaps suspension of the service charge elements, whether it's retail or centre generally, for either the management charges, because there's not a great deal of management going on, although I'm sure some of the surveyors out there would argue that that's not the case, and they may even be working harder than normal. But some of the more the softer amenities that you are not critical or core to the running of that building at its usual occupational use. How you define that is another matter, of course, but with my tenant hat on, I'd be saying, look, there's lots of things which you are in the budget that you're going to provide us for, and it's patently obvious because of this pandemic that you're not going to be doing them for the period that the government say you can't. So why should we have to pay for that? Because of course most service charges it's quarterly or monthly up front. Yes, there may be an adjustment at the end which can help, but I'd rather, personally, with my tenant hat on, I'd rather not have them in as a head of something that the landlord can claim in the first instance. So that for me would form part of the exclusions in the service charge provisions in a lease.
Yeah, I was going to say an interesting point from that is that a number of shopping centres we see at the moment obviously have anchor tenants at either end of them who are operating in essential use areas just now, so they are food. And what's the position? Is there something to be done perhaps in terms of redistribution of service charge liability during these periods, depending upon who is actually going to be benefiting from any services that are provided at this time?
I think that depends on how the service charge clause is drafted. Quite often you do have the ability for the landlord or landlord's, surveyor to adjust the percentages, depending on user, floor area, etc. So you'd have to look at the drafting and the lease, and perhaps going forward there'll be more drafting put in leases about the landlord's ability to adjust service charge percentages.
And on the tenant side, clearly you would want to try and avoid any liability you're not getting benefit from.
Yeah, I think so. As Helena says, it's the service charge schedule in the lease. If that's how it's structured, it's a contract. Good landlords who signed up to the service charge code and they are compliant. You shouldn't see things like sweepers, although dare I say they do creep in from time to time. But yeah, it'd be interesting to see what the reaction to all this is post-COVID, and whether there's more work on that on top of the guidance that's coming out. And indeed, I believe that the new code that takes effect in September, if you are an RICS member, then it's got a bit more teeth than perhaps some historic guides. Yeah, so that, which is great. The extent to which it finds itself in when you're trying to negotiate a lease, you want to open or get your fit out started the next day and it's 11 o'clock at night. How much landlords are willing to concede or tenants are willing to concede on these sorts of things, I don't know. Time will tell. But certainly, conceptually, I think it would be difficult for some landlords to say, well, look, we want to still charge you for these services, even though you're not being provided with them. But certainly for some of the softer things, I would have thought.
Yeah, just to add that the service charge code, I think it's English and Wales orientated, but generally there is, as I mentioned earlier, a philosophy of a more collegiate approach, which we see in Scotland as well. I think we started slightly late, but we're finishing slightly late as well. So I think that's our allotted hour has come and gone. So it's time to bring things to a close. If there are any other questions which have not been picked up in the question and answer session, then please feel free to contact us via the contact details for the panel, which are on the screen. I think it just remains for me to thank the panel and to thank you for joining us this morning. Hopefully you will join us again on future sessions, and until then, we'll see you again. Stay safe. Thank you. Bye now.
Thank you.
Bye-bye.
Bye.